First item only.
Item number 1.
Well, there is some defect in the pagination in this read appeal.
I've just checked in the court's brief. It seems there is something wrong, my lord.
So you have to correct it.
Yes, my lord. My friend will be here, my lord. He will do the correction, my lord.
You will have to withdraw and file friends.
There is something wrong in the pagination. Just let him, if my friend, he checks in the registry, there's some mismatch it appears, my lord. If he checks in the registry, in front of the registrar, if he does it, that can be done, my lord. In front of the registrar or assistant registrar, someone, my lord. Something wrong in the pagination.
Normally.
You want rectification?
Yes, my lord. Not a...
I'll not.
If my lord amended petition is not required to be filed, that can be done.
I'll not bother my learned friend much on the technicalities. But absolutely, there is a defect in the pagination, my lord.
So you correct it. We'll take it up on some other day.
My lord.
Yes,
my lord. My lord.
Heard Mr. P.D. Nair, learned counsel for the appellants.
When do you?
You are for the appellants.
Yes, my lord.
Yes.
Also heard Mr. T.T. Tara. You are appearing for?
For respondent number 7, my lord.
Respondent number 7. Who else is it?
4 and 6.
What's your name?
K. Loya, CGC.
Mr. K. Loya, learned Central Government Council, appearing for respondent number 4 and 6. And what's your name?
Just check yourself.
Peace?
Yes.
After 14.
Peace Sangita,
After 14.
appearing for respondent number 1, 2, 3, and 5. It is submitted by learned counsel for the appellant that the pagination in the memo of appeal, there is some error in the pagination in memo of appeal, and he seeks leave of this court to rectify the same in presence of the registrar. The prayer is allowed. Let this matter be listed after said rectification on
24th March.
Fine.
That is okay.
on 24th of March.
The corrected copy be served to the councils
Definitely.
for the parties.
That will be done, my lord.
The appellant shall submit the copies of corrected memo for appeal after correcting the pagination to the learned counsel for other sites.
My lord. Deeply.
List it on 24.
24th.
Grateful.
Deeply.
Item number 2.
Yeah, please, Lordship. Lordship, we parties are ready for final disposal.
When?
We are ready for final, Lordship, hearing
Today.
today.
Okay.
The matter will not take much time, my lord. My lord, the matter is very simple. My lord, if your lordship sees the impugned judgment, the learned single judge is very clear in the matter. My lord, where any deviation is to be done, my lord, it will have to be done by compliance of constitutional mandate. This is the only point, my lord. Here, my lord, that deviation was done without any compliance of the constitutional mandate. That is in terms of Article 154, 166, 167.
No, what is the issue here?
My lord, my learned friend is the appellant, possibly.
Yes.
He will start. Let him start with the impugned judgment, my lord.
Yes.
Lordship, before coming to the impugned order, Lordship, judgment, Lordship, I'd like to take Lordship to the brief background of the case. The background is in 3 chapters, Lordship.
Before my learned friend starts, I want to tell your lordships, he has annexed 2 documents which were not the record in the petition. So therefore, my lord, he cannot rely on that. There is annexure 2 and 3 of the writ appeal. These are quite new. It has been annexed here. So obviously, my lord, this was not before the learned single judge. So that cannot be relied at this time.
That may be considered, Lordship. Lordship, the past chapter starts with Lordship. Kindly come to page 99, Lordship.
You're taking writ appeal 54.
Writ appeal 1.
54.
54 is not there. 1 and 2.
One page is same.
Same.
Okay.
Lordship, this particular agreement,
You just see whether it is 219 and 346.
this is 2.
No, this one.
No, you tell us the gist first. What were the facts?
That I'm coming, Lordship. The background is in 3 chapters, Lordship,
Yes.
which are interlinked to each other, Lordship. The first chapter is, Lordship, kindly come to page 99, Lordship. This is for Lordship. The widening and strengthening of Itanagar to Jote Road, 20 kilometers, Lordship. This particular work was awarded to the writ petitioner, Lordship. And this is, as I've said, Lordship, this is for widening and strengthening of Itanagar to Jote Road, 20 kilometers, Lordship. Work was awarded, I'm repeating, work was awarded to the writ petitioner, Lordship. And accordingly, the work was executed by the writ petitioner, Lordship. And this agreement was signed on 10 November 2021. That may be noted, Lordship. And this particular work, it was completed on 31st March 2024. 31st March 2024. The work was completed.
Yes.
Yes.
Then kindly come to the second chapter starts, Lordship, because after 4 months after completions of this work, Lordship,
This agreement contains only one page or what?
this no, Lordship, it contains, Lordship,
Okay, you have given it type copy.
yes, 2 pages, Lordship, 2 pages, Lordship.
2 pages.
2 pages, Lordship.
The terms and conditions are differently given.
Yes, because here, Lordship, will find
This is the main agreement and terms.
this is the main
The
agreement.
general conditions are separately given. right?
Lost. Then second chapter starts, Lordship, because work was already completed. After 4 months, Lordship, what happened? Kindly come to page 104, Lordship.
This is against the tender. This
Tender.
work was given against the tender.
Tender, Lordship.
Okay.
There's no dispute so far this work is concerned. Just I am citing the
Yeah,
background. of it.
correct. We also need to understand.
Yes. Then kindly come to page 104, Lordship. The second chapter, it starts with this, Lordship. After completions of that past work, after 4 months, Lordship, this note was issued by the Honorable MLA Duimuk constituency, Lordship, of that area, Lordship.
Yes.
So I would like to read this particular note issued by the Honorable MLA, Lordship. Subject: urgent repair and reconstruction of dilapidated steel bridge on Itanagar. All the 6 existing steel bridges situated along the 20-kilometer stretch of Itanagar Jote Road are in dilapidated stage. These single line belay bridges constructed during early 90s are no longer traffic worthy. This double lane state highway connecting state capital Itanagar with NIT, FTI, Jerome Gamlin Law College, and other premier establishment assume significance in assuring overall growth of the state in terms of the human development index and the state GDP. The commitment of the state government to keep the surface communication intake and traffic worthy round the clock, therefore, cannot be overlooked. It is appreciated that Chief Engineer Western Zone has taken initiative in submitting the proposal to Government of Arunachal Pradesh for consideration in priority. It is, however, felt that the process involving sanction, tendering, etc., being time consuming, the actual commencement unlikely to materialize before 2025. The existing bridges being vulnerable to collapse at any time. This should be post.
So basically, I mean, he requested for these works to be also done.
Yes, this work also has to be granted. And what additional request he has made, Lordship? I am there for the opinion of the so maybe explore feasibility of engaging the existing contractor of this road who has successfully delivered the upgradations of roads and so. So what he requested, Lordship, the work, this work may be Lordship approved, and this work may be given to the contractor who completed the widening in East Changing. Basing on this very Lordship note, Lordship, then
No, this is a letter to,
this is by the Honorable MLA of that constituency
to whom?
to Sri Purpaji. Purpaji is the Honorable Advisor PWD, Governor of Arunachal Pradesh. He is Honorable Advisor to the Minister concerned, Lordship.
Advisor
PWD.
to which minister? PWD minister.
PWD Minister. Then it
Yes.
proceeded further, Lordship. Then ultimately, Lordship kindly come to 107, Lordship. Lordship, and type copy is 8 page 110, Lordship. 110, Lordship. Here the same has been, Lordship.
What is this?
So same thing has been, Lordship. The proposal has been, Lordship, forwarded to higher authority, Lordship. This is by the executive engineer.
No, what is this 110?
This is the, Lordship, the proposal by the department, executive engineer, Lordship. This is on the basis of that your note, Lordship. Say after that note has been issued by the Honorable MLA, that has been marked to the department, Lordship. And department has put forward this particular proposal, Lordship. It says, Lordship, same thing only, Lordship.
It was addressed to whom?
This is, Lordship, this is a file noting, Lordship. File noting marked to SC, Lordship. Kindly come to page 107, Lordship. 107, the original one, Lordship. And kindly turn to next page, Lordship. Lordship will find on left hand side, it has been marked to, this is by executive engineer, it has been marked to SC. Left hand side in the middle portion, Lordship. 108, page 108. It has been marked. This is the official noting, Lordship. Then it has been again marked to the chief engineer. Here the proposal was made to, Lordship, to award this work to additional work to the petitioner by way of extended tender, Lordship.
Yes.
This proposal ultimately, Lordship, culminated at page 113, Lordship.
No, in 110, where is that proposal that it has to be
Uh,
treated as extended tender?
Kindly come to page 111, Lordship.
111. Yes.
Paragraph 9, Lordship. Paragraph 9, Lordship. Under the prevailing circumstances, Lordship, it is recommended to adhere to the following norms compatible with CPW works manual, assigning contractor so and so. This is the BIMG Belgi is the contractor, Lordship. So that was the proposal to award this work to the BMG Belgi. That's a writ petitioner lawsuit.
No,
That-
in this proposal, what was the reasoning for bypassing the tender process?
Bypassing is the lawsuit, urgency has been expressed, as I just read, lawsuit. Because it's at the verge of collapse, anytime it may collapse. That was the lawsuit mind behind this proposal. And this proposal was initiated by the Honorable MLA lawsuit. To some extent, lawsuit, it related to the department. And ultimately, what happened, it's page 113 lawsuit.
Yes.
113, it went to up to Honorable CM lawsuit. 113 lawsuit down below. Ultimately, it has been approved by Honorable CM lawsuit. The down below lawsuit will find HCM.
Yes.
Then what happened, lawsuit? Next lawsuit kindly come to 120 lawsuit, page 120. Page 120 lawsuit. And one thing is, it's necessary to be pointed out here, lawsuit. Till this approval by till the approval of this honorable CM lawsuit, till then even the DPR was not prepared, lawsuit. Kindly come to page 120 lawsuit. This is the first communication by the executive engineer to the writ petitioner lawsuit. What it says, lawsuit. Kindly see the subject. Widening and extending of so and so and so additional work. Pursuant to the approval of competent authority by the UO Note 530 dated so and so. This is of CM, Honorable CM lawsuit. You are requested to immediately carry out subsoil investigation for 6 bridges situated at various locations of this highway for conversion from existing single lane steel bridges to double lane bridge, confirming to NH specification. The details are so and so. 6 bridges have been mentioned here, lawsuit. SSI reports along with structural design and drawing duly vetted from any NIT or IIT along with the item-wise BOQ should be submitted for each bridge in triplicate for further action. Nomenclature of the items shall be in the conformity with the specification as per the mode so and so. Payment for SSI design and drawing shall be made upon sanction and fund allocations from the government. The report should be submitted within 3 months and no extension is permitted being urgent nature of the work. You are also requested to keep the existing bridges operational by carrying out necessary repair or maintenance as and when required duly certified by field engineer.
So it started from, the process started from 31st March and this was written on 23rd September. So from March till September, already time taken, correct?
Lawsuit. Now the work shall be
And the reason shown was urgency.
urgency. Lawsuit, the work shall be, is very important, lawsuit. The work shall be taken up as additional work under the existing agreement subject to approval of BOQ and technical sanction. Determinations of work so and so. This is very important, lawsuit. So far, subsoil examination is concerned, testing is concerned, lawsuit. That is done much prior to lawsuit, DPR lawsuit. After that, only DPR is prepared, and DPR is approval by the competent authority. Then only lawsuit tender process has to be done, lawsuit, sanction lawsuit. So far, this subsoil examination testing is concerned, lawsuit. For this particular testing, fund used to be provided by the government, lawsuit, for this specific purpose, lawsuit, not for the other tender and exhibitions work, lawsuit, for this purpose only, lawsuit. So for it can be added to the DPR, lawsuit. Now, lawsuit, kindly come to page, the next page, lawsuit, 122, lawsuit. This is the one crucial document, lawsuit, in this particular case. This is dated 2011-2024 lawsuit, in the month of November 2024 lawsuit. This letter is written by assistant engineer to the writ petitioner lawsuit. as undersigned is aware of the fact that you have already started groundwork preparations for constructions of bridges in the said road. While assuring coordination and cooperation from this end, you are requested to kindly dismantle the bridge carefully, avoiding any kind of accident and major damages to bridge parts. And all the dismantled parts may kindly be handed over to the concerned junior engineer for proper office record. Out of 6 bridges, your good self may start with those bridges which are free from any encumbrance by providing proper conveyance to the traffic. In the meantime, this office self pursue for non-encumbrance of other bridges. Also, it may kindly be noted that traffic flow must not be compromised, Lordship. Lordship, the past sentence, it says, Lordship, undersigned is aware that the fact that you have already started groundwork preparation for construction work, Lordship. Here, Lordship, this is the one document, Lordship, which shows, Lordship, the work has been started, Lordship. Otherwise, there was no work order. There was no communications from the government to the writ petitioner to carry out the work, Lordship, except for these communications, Lordship. Now, Lordship, second chapter close here, Lordship. The third chapter, Lordship, kindly come to, Lordship, page 47, Lordship.
Page?
Page 47, Lordship.
Well, this is the thing, my lord, initially I told. This was never a record of the writ court. Can you rely on that?
This is
Is annexed 2 and 3.
this is a rule.
Let him make submission.
Melody,
You
yes.
may
I'm
raise
obliged.
objection.
I am not placing any, Lordship. This is the public document, Lordship, and this is the it has the post of the statutory rule, Lordship. Page 47, Lordship. This is power to the power of financial power of financial power delegation. This, Lordship.
This is an office memorandum.
Office memorandum, and this is being followed by the state of Arunachal Pradesh, Lordship. Financial power delegation, Lordship. Yeah, Lordship. May I read, Lordship, this particular?
Yes.
The grant of administrative approval, respect of plan oblique non-plan scheme oblique project oblique work, etc. Lordship. In supervisions of this office memorandum issue so and so, and notified on so and so, and office memorandum number so and so, on that so and so, and notified gazette notifications so and so. The governor of Arunachal Pradesh is pleased to delegate the financial power to accord administrative approval in respect of various authorities with immediate effect as below, Lordship. Here, Lordship, the Secretary of the Administrative Department has been given to accord administrative approval. It's up to, Lordship, 40 lakhs, Lordship. Likewise, Lordship, may I take, Lordship, to down below, Lordship. Serial number 4, Lordship. The Honorable Minister of the Administrative Department, the Minister, the power of the financial, the giving administrative approval power of the Minister is, Lordship, up to, Lordship, 1 crore, Lordship. 60 lakhs to 1 crore, Lordship. Now, above 1 crore, Lordship, Cabinet Subcommittee. Cabinet Subcommittee, Lordship, is comprised of 3 authorities, Lordship. The Honorable Chief Minister, then, Lordship, Honorable Minister, Finance, the Honorable Minister in charge, Lordship, the concerned Minister, Lordship. These 3 authorities forms a Cabinet Subcommittee who has the power to accord administrative approval for any project amount of which is more than 1 crore, Lordship. Now, in the present case, Lordship, the cost of the earlier cost of the project was the first one, Lordship, that was 65 lakhs. 65 crore, Lordship. In present case, Lordship, the additional work 80 crore, Lordship. Now power is with the Cabinet Subcommittee, Lordship. And this is the part of the financial rules only, Lordship. The rules need not to be pleaded also, Lordship. Just I am placing this office memorandum, Lordship, as a matter of law. Then Lordship kindly come to next page. Kindly come to next page. That is page 48, Lordship. This very Lordship proposal. Earlier, Lordship, in the past chapter, I have stated Lordship, it went up to Honorable CM Lordship. That is prior to Lordship, the preparations of DPR Lordship. Ultimately, DPR and all was prepared. And it seems Lordship, it was placed before the Cabinet Subcommittee Lordship. Page 48 Lordship.
In respect of these six
This
bridges.
same project Lordship.
Okay.
Same project. Because as I have taken Lordship to the power of the administrative approval Lordship, the Cabinet Subcommittee has the power Lordship. This is not it. It starts from here, Lordship. Lordship will find name of the works and ancillary works on so and so. Construction of 6 bridges, Lordship. On third paragraph, Lordship. Then here the proposal has been that down below, Lordship. In view of the fund release as above, an administrative approval to the so and so may please be obtained from the Cabinet Subcommittee to the Honorable Advisor Western Zone so and so, and thereafter file may be endorsed to Finance Department for a code of finance concurrence of rupees so and so with an expenditure restricted to rupees so and so during so and so as per fund provision, Lordship. Then ultimately, Lordship, kindly come to page 50, Lordship. 50 Lordship. It passes through from table to table,
So it happened when?
Lordship. This is on Lordship 7 to 2025, Lordship. Kindly come to page 48. Then date of the page 48 is kindly come to page 49, Lordship.
Yes, 7 to 2025, yes.
7 to 205, 2025, Lordship. Then kindly come to note 9, Lordship, at page 50. Page note, Lordship, 9. An administrative approval to the tune of rupees so has been obtained from the Cabinet Subcommittee in a one go by file number so and so. And this approval has been given on 19 to 2025, Lordship. 19 to 2025, Lordship. And that first and second chapter that ends in the 2024 only, Lordship. Now this is 2025, Lordship, which is actually placed before the Cabinet Subcommittee, Lordship. Now, kindly hear what it says. Hence, the proposal may be put forward directly to the Finance Department. Second, I'm reading the second paragraph, Lordship. For a code of finance concurrence to tune of rupees so and so, with an expenditure restricted to so and so, during so as per the so and so and so. What after administrative approval has been given by the Cabinet Subcommittee, then financial concurrence is required. For direction has been given to place it before the Finance Department, Lordship. Then again, it ultimately the finance concurrence has been given, Lordship. That is page 57, Lordship. 57. This is the finance concurrence given by the note. This is note 37. It's the continuation note only, Lordship. And this is the extract from the e-file, Lordship. Page note 37 at page 57, Lordship. This is the finance concurrence given by the Finance Department to this very project, Lordship. Then I'm taking, Lordship, to the relevant only, directly to close the condition number 12, Lordship. Condition number 12. That is at page 58, Lordship. The executions of the work oblique scheme oblique project and procurement of item oblique materials furniture should be done strictly as per provisions of GAPR, DAPR, CPW manual, etc. All the financial rules and regulation, the guidelines and directive issued by Government of India, Ministry of Finance, Government of India and Ministry of Government of India, CBC, and the Government of Arunachal Pradesh in this regard from time to time should be followed in letter and spirit without fail. The process of tendering and competitive bidding should mandatorily be followed and complied with as envisaged in DPR, FPR, financial rules and regulation and the conditions, guidelines, circulars and directive issued prescribed by the Government of India, CBC, and so here this particular project has been approved by the Finance Department on specific terms and conditions. Now what happened after this has been approved?
So this was done on?
This is done on kindly come to page 6060
50?
6060.
Yes, this was
On the above top 11/3/2025.
11/3/2025.
Then kindly come to page 181 also.
One?
Sorry, 197 also.
190.
197. From Cabinet Lordship, approval was accorded, then Finance Department, then it came back to the Lordship Concerned Department, this is Public Works Department Lordship.
Page 191.
197 Lordship. 197. This is a sanction order. This sanction order dated on prompt lordship, it's dated 11 March 2025, but signed on 18 March 2025 lordship. And I'm taking lordship to the condition number 12 here lordship. Page 197. The condition 12. The executions of the work is
This is administrative approval and financial sanction.
no. So per this yes, this is by the concerned department because administrative approval has been taken from the cabinet subcommittee. It has been supported by the finance concurrence lordship, and this is the lordship administrative approval and expenditure sanction by the concerned department in terms of the approval given by the cabinet and finance department lordship. And thereafter, lordship, tender and all has to be started, lordship, after this sanction order has been issued, lordship. Now, condition number 12, lordship, the execution of the work scheme so and so should be done strictly as per provisions of GFR so and so, all the financial rules and regulation, the guidelines and directive issued by the Government of India, Ministry of so and so, CBC in so and so. The work shall be carried out through extended tender as per approval of so and so 2024 lordship, which was not the part of the lordship, the approval given by the finance department lordship. What it says of the, because earlier lordship, Honorable Chief Minister approved in the earlier second chapter. So this But so for the finance concurrence, the conditions, this was not the part of the condition lawsuit. Then what happened? Then kindly come to next page, that is page 199 lawsuit. This is a corrigendum lawsuit.
What do you mean by extended tender?
Lawsuit, that also lawsuit, the government has done this particular by awarded new work to some same existing contractor by way of extended tender lawsuit. But to my understanding, lawsuit, so far extended tender is something stranger to the lawsuit, the law of contract lawsuit. Ancillary and incidental to the work by way of revised, that is permissible lawsuit.
That scope can be always deviated.
Yes, that is official based lawsuit. But extended tender, to my understanding, is stranger to the law of contract. That's my understanding, lawsuit. But it's an act of the government, so with embarrassment, I'm submitting this lawsuit. And this corrigendum at page 199 lawsuit. By this corrigendum lawsuit, that clause 12 has been corrected lawsuit. Kindly see. The administrative approval and expenditure sanction number so and so relating to so and so work so and so Itanagar under so and so with an estimated cost of rupees so and so with expenditure restricted to so and so is cancelled due to presence of some unintentional error in clause 12 of the above modified order. Now, new administrative approval and sanction is issued by number so and so, replacing / supersede the above mentioned order. So this past error encrypted in the past this sanction order that has been lawsuit corrected at page next lawsuit.
Page 200.
Page 200 lawsuit. And at page 200 lawsuit, clause 12 lawsuit, that is in conformity with the
So the extended is not there.
extended is not here.
So that has been removed.
That has been removed.
Yes.
And that was also not the part of the finance concurrence lawsuit. So this particular administrative approval is in consonance with the lawsuit, the financial approval. Then lawsuit, I'm coming lawsuit, taking lawsuit to the impugned order lawsuit. After it has been sanctioned by the concerned department, then what happened lawsuit? Because work is being carried out into over 2 bridges.
So by that assistant engineer's work, they started working. And they completed the work. Half of the work they've completed.
Yes, Lord.
Some works they've
One
on the basis of that order, go ahead order by the that page 122, right?
Therefore, lawsuit, I took lawsuit I pray lawsuit that particular letter may be lawsuit minorly observed. Here in the past line it says lawsuit as aware that you have already started the work lawsuit. And whereas there was no communications on records to directing the petitioner to start the work.
And your case is that like he is not authorized because he doesn't have the power to give, order this work.
That is one aspect lawsuit. Now my case is coming lawsuit, which is impugned in the writ petition lawsuit.
Okay.
Kindly come to page lawsuit.
Now, what is the status of work now?
Work one bridge almost completed, and second bridge also almost lawsuit done lawsuit.
So two bridges they have already completed.
Almost completed, as I am informed lawsuit.
And for those 2 bridges, money have been paid? Bills
Money
have been
lawsuit,
paid, money paid?
that part I have to take instruction. That part I have to take instruction.
Some amount is paid, my lord, not whole.
So some amount is paid.
25% possibly they have paid.
Okay, some amount is paid. Then kindly come to page 144 lawsuit. (144). 144 is the impugned order in the, there were two writ petition lordship, which were lordship disposed of by common judgment. This is the impugned order in first writ petition, that is 219 of 2025 lordship. What it says, lordship? This is dated 29/3/2026 lordship. After lordship, the administrative approval and sanction has been issued by the concerned department, that is the Public Works Department. This is a letter by the executive engineer to the writ petitioner. May I read, lordship? Please refer to this office letter, that is number so and so and so. The competent authority has approved design/drawing and subsequently accorded technical sanction based on BOQ submitted by you. It has been further decided to implement the project during the meeting chaired by Chief Engineer on so and so by segregating in two parts as under. Bridge over Dokoso and Gera Nala as extended portion of agreement so and so for regularizations being already executed nearing completion. Here it means the lordship.
So they have segregated into two parts.
Two parts.
The work they have already done, and like remaining part is another part.
That remaining part will be by plotting press tender lordship. Now government one lordship, the work being carried out by you, though is not legal, but since you are already almost completed, we will regularize that. But the rest work lordship, that will go for tender. That is the decisions of the authority. And next is lordship, turn to next page lordship, page dated 24/4/2025 lordship. This is also by executive engineer to the writ petitioner with reference to so and so and so, where he has directed to stop the bridges so and so. Therefore, you are asked to stop the so and so. He has been asked to stop the works lordship. And these two communications were challenged by the writ petitioner in the writ petition 219 lordship. Now, how it has been considered by the learned single bench lordship? Lordship, tender is the law. Tender is the law, lordship. But in some exceptional cases, lordship, in case of urgency lordship, there may be by work order lordship, and that is on limited lordship, very limited area where it can be done lordship. Now may I take lordship to the impugned judgment of the same.
Page?
It starts from page lordship 25.
Yes.
Lordship, I'm taking lordship to page 45 lordship. Para 26.
Page 25,
Page 45.
page?
It starts from page 25, but I'm taking lordship to the page 45 lordship, the relevant portion lordship. Operating portion. Page 45 lordship. Para 26.
Yes.
Although the learned additional advocate general has sought to impress upon the court that cabinet approval was required to be taken up for allotment of the said work, but the fact remains that the approval of Honorable Chief Minister has been taken after file was routed through the department, the administrative head of the department, and the advisor ways. Further, the order dated so and so, by which administrative approval and administrative sanction was given by the governor before the corrigendum or even after the corrigendum is with the concurrence with the finance department. Such being the position, the allotment of works to the petitioner firm cannot be termed to be irregular or illegal for that matter. On contrary, in view of the Rule 21 so and so, Honorable Parties Rules of Executive Business 1987, read with clause so and so of the schedule, to the said rules proposal to vary and reverse the decisions taken earlier will have to be placed before the cabinet. I therefore find force in the argument made by the learned senior counsel for the petitioner. Therefore, upon such considerations of case in its entirety, the impugned communications are found to be not sustainable and are accordingly set aside. The interim order passed earlier stands merged with this order, having so and so authority so and so and so. This is the lawsuit. Now I'm taking lawsuit to the my affidavit lawsuit. My affidavit, page 181 lawsuit. (181) and relevant is page 183, paragraph 3 lawsuit. In paragraph 3 lawsuit, I have cited almost all the grounds lawsuit. As per general financial rules, Rule 130 lawsuit, what constitute the original lawsuit work that has been defined lawsuit. So, for the present work is concerned, it's a completely independent work lawsuit, which is supposed to be awarded through a tender lawsuit as per the law. And Rule 139 lawsuit of General Financial Rules 2017. Also, I have cited lawsuit.
Rule 1?
These lawsuit, better last time lawsuit, I produced one bunch of sets of rules lawsuit. Kindly see if it's available.
These general financial rules, right?
Yes, except for general financial rules.
No, you are referring to which rule?
Rule lawsuit 130.
130.
130 lawsuit. Kindly see this extract of General Finance Rules of 2017 lawsuit. And in very first page lawsuit, Rule 30 it starts with the Rule 30 only lawsuit. Original work means all new construction, site preparation, additions, and alterations to existing work, special repairs to newly purchased or previously abandoned. As per this definition lawsuit, the present works comes under the original works lawsuit, a separate independent work lawsuit. That just wanted to. Now, Rule 132, power to sanction works lawsuit. As per who have been delegated with the power lawsuit, they are the only authority who can lawsuit sanction the project lawsuit. Then kindly come to down below, left hand side, right hand side lawsuit, Rule 136 lawsuit. No work shall be commenced or liability incur in the connection with it until the administrative approval has been obtained from the appropriate authority in each case. Work even cannot be started without lawsuit administration. Then kindly come to page Rule 139 lawsuit. 139 on top right hand side lawsuit. This is a procedure for execution of the work lawsuit. I'm taking lawsuit to the clause 3 lawsuit. Kindly relevant is clause 3, clause 4 lawsuit. No work shall be undertaken before issue of administrative approval and expenditure sanctioned by the competent authority in the basis of estimated frame lawsuit. Open tender will be called for the works costing so and so and so. This is the mandate provided by the General Financial Rules lawsuit. Then kindly come to page next page. I've done pagination for lawsuit. Page top pagination has been
Page 4.
Page 4. This is the CBC guidelines. And this guidelines has been issued in terms of the lawsuit Nagar Nigam Meerut that case 2006 13 SCC 382 lawsuit. Well lawsuit
What was the citation?
lawsuit 2006
Hmm?
13 SCC
Hmm?
382.
See it not going even.
I've given the list also.
Okay.
And this particular CBC guidelines was issued by the central government, CBC, that commission, basing on this lawsuit, which
Yes.
it's mandated lawsuit in public work lawsuit. That's the lawsuit. So now at this junction lawsuit, my submission is the lawsuit. Tender is the law lawsuit. And learned single bench lawsuit render its judgment without any, in deviation from that law, but without citing any region law.
What is page 8? That bunch of documents? That Arunachal Pradesh. District and
Yes,
Capital-
this is lawsuit. This is the act of our own state lawsuit.
What does it say?
This lawsuit, who are entitled, eligible to participate in the tender process lawsuit. This is basically how the preference has to be given. On that basis, this act was enacted. So kindly come to page 9 lawsuit. Page 9 lawsuit.
So works up to.
20 lakhs lawsuit. All registered contractor in class friends.
Your work is 50 lakhs to 1 crore.
Yes, lawsuit.
Yours is 80 crore, right?
80 crore.
80 crore.
80 crore.
So 80 crore will come in
7 lawsuit.
7.
Lawsuit.
So this has to be given
Open to all
registered contractors
in
in
appropriate
class.
class. And kindly come to page next lawsuit. That is page 10 lawsuit.
Mm.
This is the lawsuit the works, nature of works, list of the nature of works. A2 lawsuit K.
Mm.
This is the works on which lawsuit the work can be given up to 50 lakhs by work order also without tender lawsuit. And this is in terms of section 3A. 3A, the 3 is here given lawsuit.
Okay, up to 50 lakhs.
Up to 50 lakhs lawsuit.
So here basically you want to share that registered contractors in appropriate class has to be
Lawsuit.
only can.
Now, only issue here is the lawsuit. Just we want to go for tender lawsuit. Accordingly, we have issued letter to stop the work and rest will go for the tender.
So there was neither any tender process nor any work order, apart from what has been shown in page 122.
Correct.
Apart from that letter of the assistant engineer,
Correct.
no work order.
No.
And work,
And that is prior to sanction. Though after the Honorable CM that approval, but prior to sanction by the Cabinet Subcommittee.
Impugned order, impugned judgment and order, other than that para that you have shown, anything else which has been discussed
Now, no.
which may be relevant?
Lawsuit, what I'm in the past, my lawsuit contention is the lawsuit. I said lawsuit, as per rule, tender has to be floated lawsuit. That has not been answered. That has not been considered lawsuit with that learned single bench law. This my past
So your prayer is very simple. You say there like whatever work done,
done.
because at that time sanction was not given. And maybe the work order, I mean, maybe the go ahead letter was issued by an unauthorized person. So whatever work you have done. And the later part, we should be given an authority to go ahead with the tender process. That is your.
That is my simple case lawsuit.
and where the single judge heard.
Because by 2 impugned order lawsuit, I direct
Any discussions on those?
lawsuit.
Can you show us from the impugned order?
Lordship, that part, what I'm submitting is the Lordship. Therefore, Lordship, impugned order is start from page 25 up to 46, Lordship. That legal basis has not been, Lordship, discussed much. Only the relevant is page paragraph 26 at page 45, Lordship.
Okay.
Now, as I submitted, Lordship, my case was not considered by the learned single bench, Lordship. And when, Lordship, and there are some more instances as per the affidavit filed by the petitioner, additional affidavit, that in some other places also, by way of extended tender, the work has been given, Lordship. It was not brought before this honor court, but it was carried out and finished, Lordship. And on this very particular point, Lordship, if the authority is doing something in deviation from the established rules, Lordship, there is something deviation, Lordship, and that cannot be advanced by this court of law, Lordship. That's my one submission, Lordship. And third is, Lordship, the petitioner, Lordship, he has no enforceable right to have it done through him only, Lordship, without tender, Lordship.
Yes.
So basically, this is my, Lordship, sum up submission, Lordship, these three issues. Because learned single bench has gone against the law, Lordship.
Any
But-
case laws that you have relied on?
Lordship, I am relying on only this Nagar Nigam only, Lordship.
Okay.
Where it says, Lordship, tender is in the public. That's all, Lord.
May it please your lordships. My lord, I will take your lordships first to the approval given by the authority, that is by the Honorable Chief Minister. Your lordship may turn to page 113, my lord. I'll take your lordships to the type out portion at 114. Lordship got it.
Yes.
Proposal for replacement of dilapidated single lane steel bridges to double lane bridges conforming to highway specification recommended by the CPWD West Zone has been examined with findings as under. The project upgradation of Itanagar Jote Road to State Highway under Papumpare District, 24.960 kilometer was conceived during the year so and so. Original project cost of rupees, your lordship kindly mark this. Original project cost of rupees 153.97 crore. However, could not be considered at one go, thereby delinking the bridge components from the scope, and accordingly rupees 89.52 crore was sanctioned under so and so. But the entire scheme was originally 153. That is 20 kilometer road as well as 6 bridges. But as there was a financial constraint, possibly, my lord, that was changed. Now it is reported that all the existing 6 bridges are no longer considered safe, having outlived lifespan and require immediate replacement retrofitting measures to avoid any accident, collapse during plying of trucks and other heavy vehicles in this road. Due to importance of this highway from strategic point as well as all-weather connectivity aspect of prestigious national institutions like NIT, FTI, etc., the proposal can be tagged within the ambit of works of inescapable nature. My lord, I will take your lordship to the CPWD manual in regard to inescapable nature given at para 1.5 of CPWD works manual. This office has already taken up the matter with the director of planning, earmarked so and so, so and so. Being an inseparable component of single project, the balance work can be taken up through the same agency as suggested by the Honorable MLA and recommended by Chief Engineer West Zone. As per the feedbacks document furnished by Executive Engineer Daimuk, contractor Messrs. Bhimji Velji Swarathi Construction Private Limited, there is my lord the respondent here. They executed 2 highway projects in the state of Arunachal Pradesh having both road as well as the major bridges, totaling 5 number under so and so, so and so. Now it has been shown that their credibility, my lord. The credential of the firm as established from above indicates about the financial as well as technical capability for undertaking the bridge work as recommended by Chief Engineer West Zone. This is important, my lord. The methodology and terms of procurement can be considered as additional work by extending the agreement as already applied earlier, similar to SEPA so and so road, NEC project approved by so and so. That is the modalities is through extended contract that has been accepted.
28/8/2024, right?
Exactly, my lord.
Much after the go-ahead order.
Yes, yes. Now, your lordship may see the page 113. In the left-hand side, your lordship will find the bottom. Honorable Chief Minister has approved that.
No, where is that? I could not see it. I mean,
My lord,
it is for approval.
page 113,
Yes.
the left-hand column, your lordship, down below your lordship, kindly see in the left-hand side.
Mhm.
HCM, Honorable CM.
No, for approval of Honorable CM, please.
Yes, yes.
That could be seen.
That he has signed. Honorable Chief Minister has signed.
Where
My
is
lord,
the signatures?
yes, the signature your lordship will find is not my lord, accepted by even the other side also. My lord, Honorable CM down below your lordship will find that is his signature.
Where? Only HCM is,
HCM then below, my lord. He is the PWD minister also. In the bracket your lordship will find PWD. He is the Honorable Chief Minister as well as the concerned minister of the department, that is PWD. Therefore, your lordship will find in the bracket.
So this is not disputed by them.
No, it's not disputed, my lord, that is accepted. And in the
but
left,
when this approval was granted,
that your lordship will find O, O number 530 in the left hand side. EO, no? EO number your lordship will find in the left hand side horizontally. EO number 530
2024.
17/9/2024.
that was when the note was put up,
Exactly.
Yes.
when it was approved.
That was approved on 17/9/2024.
How you can say? So?
Well, that seal is there, your lordship will find. EO number in the left hand side horizontally, your lordship will find. Your lordship got it. It is written EO number 530 dated 17/9/2024. Chief Minister Office, Arunachal Pradesh, Itanagar.
What is EO, by the way?
EO is what? That I'll have to check it up. Some official number possibly. Your lordship will find the reference of this number. I'll take your lordship to this DPR and all that. Even the chief engineer, my lord, he himself, after the so-called corrigendum, he has again accepted this position because there is no way out. Because this was culminated, my learned and possibly argued, the note, these are all note sheet. This cannot be constituted to be an administrative, executive order. This is not correct at all. It has been culminated into executive order in on 18/3/2025. I'll take your lordship to that. Now, this is the entire thing, my lord. Now, any governmental decision is a government contract in terms of Article 298, 299 of the Constitution.
No, why the tender process was not taken?
Yes, that's the thing, my lord. I will take your lordships in the type written at page 114. Column 5, your lordship kindly see. Being an inseparable component of single project, the balance work can be taken. And before that, para 3 is reported that all the existing 6 bridges are no longer considered safe, having outlived lifespan, and require immediate replacement, retrofitting measures to avoid any accident, collapse during plying of trucks and other heavy vehicles in this road. Due to importance of this highway from strategic point as well as at all weather connectivity aspect to prestigious national institutions like so and so, the proposal can be tagged within the ambit of works of inescapable nature given at para 1.5 of PWD works manual. My lord, I'd like to take your lordships to the, my lord, this 1.5, then the matter will be very clear, my lord. Give me that manual. Wait. My lord, your lordship, just for a file, have a glance on 1.5 of CPWD manual. One booklet, the last time it was given, possibly it may be in the record also. The load sheet, your lordship may see. One 1.5, works of inescapable nature. Various works of inescapable nature can be classified as under emergent works. These are emergency works which arise all of a sudden and are of inescapable nature requiring immediate action that cannot brook any delay. Like number 1, your lordship may skip. Now your lordship.
One is not, this is not emergent work.
Roman 2, my lord, your lordship kindly see that. Roman 2. Other causes like explosion, arson, fire, war, sudden collapse of building, bridge. We are on that bridge.
Is there any sudden collapse?
My lord, your lordship has seen the office note, the opinion of the chief engineer, the earlier your lordship has seen. These are all outlived the lifespan of the bridges.
No, that is a different aspect. The definition,
This is sudden collapse.
sudden collapse,
Sudden,
It has suddenly collapsed, so it needs repair
immediate.
urgently.
here what happened, my lord, your lordship has seen the suggestion of the honorable MLA. I'll take your lordship
No, that
once
we
again.
have seen, that we have seen.
Yes. Then even the official also has accepted that position.
What?
My lord, that I have just read out. It is reported that all the existing 6 bridges are no longer considered safe, having outlived the
But
lifespan.
there is a difference between considering something no longer same and sudden collapse within.
I understand, my lord, the
to bring
literal
in
meaning.
the
Yes,
meaning of
your lordship is very right.
work of a inexplicable nature.
Right, literal meaning, a slight difference is there. But then, my lord, when the wording in such a manner, now supposing any accident occurs, then, my lord, there will be, my lord, the many people may die also.
Now, after 2 years of that approval by Chief Minister, now what is the condition of those 4 remaining bridges?
The 4 remaining bridges, my lord, the status report is there in this booklet, your lordship. I'll just take your lordship to that. Your lordship may kindly see at page 240. here.
Yes.
My lord, your lordship may see page 240. Bridge over Dokosonala, my lord. It's completed and 40% payment has been received. Then bridge over Bath Nala, earthwork excavation and PCCB is completed. It was as on 9/4/2025. Number 3, Moin Nala, that is one side earthwork excavation for open foundation completed. Number 4, there is no work. Number 5, 45% completed and 40% payment has been received. Number 6, out of 6 numbers, 3 numbers pile foundation of mid pair completed and 1 number 50% completed. Now this is the status report in regard to the 6 bridges.
No. How these bridges are usable,
Two the people are using, my lord.
completed bridge.
Yes, completed these
And
2.
we,
Otherwise, there would have been a havoc. There would have been no linkage of going to, my lord, in this NITA or what is NIT, FTA and all that.
So impugned order was passed when? When was the impugned order passed?
Yes, that was passed on
29 March, Lordship.
29 March.
29 March, Lordship.
Yes, 29 March 2025. Yeah?
my lord.
And prior to that, Lordship, also 21 January, Lordship. 21 January and 21 February. That's impugned in another writ petition. Also. There also we have directed to stop the work. There's a month of this.
Direction of stopping the works is not required, my lord. They are not paying any fund. Now, otherwise also it is stopped. Direction of the PWD is not required. The work is already stopped. He will not pay for how long this contractor will pay from his pocket. Now, my lord, the greater question, your lordship, here, what has to be, my lord, adjudicated, what the learned single judge has adjudicated. Now, the question is, my lord, when the authority has taken a decision, that decision was culminated into, my lord, executive order. I will take your lordship to that first. Lordship may see the order dated 18/3/2025 at page 197. This will be the very short question, my lord, precisely to be answered.
197.
197. This is, my lord, then executive order as understood in terms of Article 154, 161, 162, 167 of the
this is the
Constitution.
administrative work approval as well as financial approval
Yes,
to a particular project.
exactly. My lord, I'll take your lordship to that part.
Yes.
Now, this order was, in fact, it was passed on 18/3 in the next page 198, your lordship will find, 18/3/2025. The governor of Arunachal Pradesh, as your lordship knows that any order passed, the expression it should be in the name of the governor. Therefore, your lordship will find the governor of Arunachal Pradesh is pleased to accord administrative approval
Where are you reading?
at
197.
page 197. my lord.
Yes.
The governor of Arunachal Pradesh is pleased to accord administrative approval and expenditure sanction not exceeding so and so as the estimated cost for 6 numbers double lane bridges and ancillary works on Itanagar Joti Road under so and so so and so. Then straightway I'll take your lordships to clause 12. The execution of works, schemes, projects, and procurement of items, materials, furniture, etc. should be done strictly as per the provision of so and so, CPW manual, etc. All the financial rules and regulations, the guidelines and directives issued by Government of India, Ministry of Finance, Government of India Administrative Ministry of so and so. In this regard, from time to time should be
But
followed.
this is already cancelled.
No, my lord. The answer I am giving you. The work.
Once it is cancelled, what is the point of reading this?
No, this is not cancelled. It is holding the field.
How?
My lord, my learned friend did
This
not.
has been
no.
modified.
Beg your pardon.
The last line has
No,
been
that modification, I am coming to that, my lord. I will take your lordship to that. my learned friend did not answer it in proper way. The constitutional mandate was not followed while modifying the thing. It cannot be said to be a modification. Because anything you debate, my lord, this is the first order, your lordship kindly see. This is the executive order in terms of constitutional mandate.
Yes.
When passing this order, the constitutional mandate as well as, my lord, the rules of executive business was followed in toto. Now, the moment you want to deviate from these, the same procedure will have to follow. Now, whether this procedure was followed or not, that has to be answered. My lord, I'll take your lordship to the impugned judgment now. The page,
No.
the last para.
Before that, Mr.
Yes.
Datta. This 11/3/2025 was an administrative approval
Yes,
order communicating administrative approval as well as financial.
yes,
You want to say that this is also a work order for you?
yes, my lord. This is a substantial order. It is holding the field still. Because, my lord, this was passed
Read that line, which
12.
last line.
My lord, the last line you lordship will find, the work shall be carried out through extended tender. as
What is
per-
extended tender?
Extended tender, my lord. This, as your lordship has seen, I'll take your lordship once again at page. Your lordship may kindly turn to page 114, my lord. Clause 2. The original project cost of rupees 153.97 crore, however, could not be considered at one go, thereby delinking the breach components from the scope, and accordingly so-and-so was sanctioned under so-and-so. Now, in fact, these two works, construction or road.
You can't link that document with this.
No, why I'm saying so, my lord, there is a reason. Extended contract means a contract is there, and in linkage with that work, it was given, my lord, there are.
Can you show me from any legal dictionary or any contract works where you can find this extended contract term? I at least till now I haven't found.
My lord, it has been followed by the state of Arunachal Pradesh. My lord,
Extended contract term, the term of extended.
No, we want to understand the meaning.
extended contracts means the contract which is already there. With that, my lord, this work is also, because these are inseparable.
It
This-
was separable. That's why, I mean, at that point of time, it was not taken up. Because these two contracts could be executed by two separate contracts. That's why those parts were kept differently at that point in time when the inception happened and the contract was executed. So you can't say that this is inseparable.
My lord, actually department has agreed and they have, the chief minister has approved even.
No, whether chief minister
And-
has the power to approve it.
My lord, and your lordship, on the top of everything, your lordship will find this very approval of the order of the honorable chief minister has been culminated into a governmental order as ratified by the governor. Now, when the governor has ratified, now there is a, you want to deviate, if you want to deviate, there is a way. It'll have to be placed before the cabinet once again, approved by the chief minister. Chief minister will send it to the governor. The governor will notify in terms of the rules of executive business. Now, that is the law, my lord, in holding the field. And your lordship will find modification part that is from the extended tender to e-tender, my lord, that they have done by a corrigendum. Now, you are making some modification. Now, when you do it, and the rule, let's see the rules of executive business for a while.
Mr. Dutta. The earlier work was allotted to you
Yes.
by issuing proper NIT. Tender process was followed, earlier work.
Yes, yes.
Now, where is the extended tender, which extend the,
My lord, what I'm saying, my lord, it has not been denied by the chief engineer even your lordship, interesting part, your lordship will find, even after the so-called corrigendum, the chief engineer, after that corrigendum was done on 21/3, chief engineer has accepted the extended contract on
No.
25/3.
Suppose you have accepted, chief engineer has also accepted. Court want to understand, where is that extended tender? What are the terms and conditions?
In regard to extended tender.
Yes.
My lord, so far this contract works is prevailing, your lordship. Can I take your lordships to 3 contracts was done in that manner?
But there,
No,
but there is no work order in this
Wow.
contract itself.
No,
Okay.
Now, for this 6 bridges, is there any work order?
No, so for the 6 bridges, it is within the,
Without any work order?
no, within the ambit of
Where is
extended
where
contract.
is the original agreement?
Yes,
There was an agreement.
original agreement your lordship will find
Page 99 also.
at page
99.
99. This is in regard to this 20-kilometer route.
So basically, you have performed the work without any work order, only on the basis of go ahead by that assistant engineer.
No, my lord, this is under the ambit of extended contract, and your lordship.
Where is that extended contract or extended tender? The word used is in the,
Let us see DPR, my lord. DPR will be the reply to that. If I take your lordships to page 139.
And I mean, this is a public contract.
Yes.
Official notes are fine, sanctioning is fine, everything is fine. But where is the work order?
Work
Where is the
order,
extended contract, as my lord is saying? Where is that? Without any terms and condition, without payment terms, without this thing, I mean, how a contract can exist? I mean,
Well,
all
Lord-
CBC guidelines, all rules, regulations, financial rules have been violated.
no,
Apparently.
not this, my lord. Your lordship has seen the 1.5 of the CPWD manual. This is in terms of that only.
CPW manual doesn't say so.
My lord, 1.5, your lordship kindly see.
We have seen this. Some scope of variation of work, scope of work is, I mean, some ancillary.
No,
work has to be
even
done.
my lord, that
Some
can be.
consent work has to be done. Those can be done without.
Your lordship kindly see once again, even the.
But the
So far-
original contract is valued at 65 crores, then like 80 crores contract is given without any contract, without any work order.
My lord, in CPWD manual, your lordship will see the last para. Such emergent works can be executed without call of tenders. By
such
issuing-
it
by-
has to be within contingency as provided within clause 2. Clause 2 provides fire, war, and sudden collapse of bridge.
My lord,
Yours
when,
is,
now I'll reply to this. My lord, honorable MLA has said is in the verge of collapse. Should we wait for the moment it will be over? Then only we shall, seeing that position, my lord, honorable MLA has said, you go for it, otherwise there will be
See,
some.
2 years is a huge, long time to float a tender, call for a tender, and give it to a competitive bidder. Isn't it? 2 years of-
Now, can I take your lordships to
So, I
the,
mean, how this emergent and sudden work will come here?
no, your lordship kindly appreciate 1.5 once again. The last para, such emergent work can be executed without call of tenders by issuing work order or on
In your
hand
contract, there
receipt.
is no work order also.
No, work order means, my lord, there are so
There
many
has to be a
letters.
work order, there has to be an agreement.
where is the work?
My lord, the officer asking me to dismantle the bridges, start the
I
work.
mean, only by saying you will do it.
Have they stopped?
You are being a, I mean, wise businessman.
No, my lord, have they stopped me?
No, I mean,
doing the
wise
work?
businessman. I mean, somebody, a junior officer says you do the work, 80 crores of work. You will go on doing it.
My lord, with a good faith I have done. Now, if I am encountered with these questions, it will be very costly for me. So nobody will,
No, that is why government has taken a sane decision.
that decision I am asking for, your lordship kindly see whether government can modify on their own in whimsically. Because there is system, there is constitutional provision. You'll have to go by that.
The authority who can use, issue one order that can cancel it also modify it.
No, and that's the thing I'm saying. Your lordship kindly see the rules of executive business. No, this is a mandatory provision, my lord, that the government can't do that way. Your Lordship, kindly see that.
No, I don't think
If he,
that's
if,
necessary.
if they want to deviate, there is a way they will have to follow the constitutional provision. My lord, first I will take your lordships to Article 154. Government cannot do at their whims. Modification, tomorrow they will come up. I want to modify. It's not up to the chief engineer. It's up to the governor. It will have to be placed by the cabinet. The CM will have to approve it. Oh, where are those things were done here? No public will come up for do all these works any further if it goes like this. Your Lordship, kindly see Article 154.
Otherwise also, no public will come if the matter is not known to public and it is given to some. In
May-
your case, public is otherwise also not knowing who is doing this work, who is getting the work.
My lord, here is a thing, a person has volunteered himself, has worked so long, government hasn't stopped it. All of a sudden, chief engineer thought, it might be because of some extraneous circumstances, he said you stop the works. Where from the law with him to do so? Whether law obligates him to do pass such an order?
Whether
There-
law
there is a
oblig- no, whether
constitution.
law obligates this executive, assistant engineer to pass an order to carry on the work of worth 80 crores without any financial sanction,
No.
without any.
If assistant engineer is asking me to do the work, how I will know he doesn't have the power?
That's what that.
My lord,
You are a
a
wise businessman.
contractor, whether he has got power or not,
You are
how
a
I
wise-
can?
You are a wise businessman. Mr.
No, I have my reservation on
You are,
that.
you are a wise businessman.
Now I want to,
You are performing so many contracts in all over India and you do not know who has the authority to pass an order.
my lord,
to
it's a
execute
very,
your work.
it will be very
That's-
costly
that's
things,
very,
my lord. It will be
that's-
damaging for the state even.
That is very amusing.
My lord, your lordship kindly see Article 154. I'm on the constitutional provision, my lord, your lordship kindly allow me to do that. Executive power of state. The executive power of the state shall be vested in the governor and shall be exercised by him either directly or through officers subordinate to him in accordance with the constitution. This is first. Then your lordship kindly see 162. Extent of executive power of state. Subject to the provision of this constitution, the executive power of a state shall extend to the matters with respect to which the legislature of the state has power to make laws, provided that in any manner with respect to which the legislature of a state and parliament have power to make laws, the executive power of the state shall be subject to and limited by the executive power expressly conferred by this constitution or by any law made by parliament upon the union or authorities thereof. Then the council of ministers to aid and advise governor. There shall be council of ministers and the chief minister at the head to aid and advise the governor in the exercise of his functions, except in so far as he is by or under this constitution required to exercise his functions or any of them in his discretion. If any question arises whether any matter is or is not in a matter as a respect which the governor is by or under this constitution required to act in his discretion, the decision of the governor in his discretion shall be final, and the validity of anything done by the governor shall not be called in question on the ground that he ought or not to have acted in his discretion. The question whether any, and if so, what advice was tendered by ministers of the governor shall not be required in any court. Then 166, this is very important, my lord. Conduct of business of the government of a state. All executive actions of the government of a state shall be expressed to be taken in the name of the governor. Now here your lordship will find any, my lord, government transaction that have to be expressed in the name of the governor. Now, the modification order, whether it is issued in the name of the governor, that will be my first query, my lord. The second, order and other instrument made and executed in the name of the governor shall be authenticated in such manner as may be specified in rules to be made by the governor. Now, the order may be authenticated with the governor himself, in some cases by the secretary, when it is authenticated by the governor himself. Third one, the governor shall make rules for the more convenient transaction of the business of the government of a state and for allocation among ministers of the said business, insofar as it is not business with respect to which the governor, that's a different thing. Now, your lordship will find, so far 166.3 is concerned, this is mandatory. My lord, any rule framed by the governor, there is the rules of executive business, it is mandatory in the sense, what way the government will make a function of business that will have to be spelled out there. Now here what happened, my lord, in terms of 166.3, the rules of executive business has been framed. You have extra copy? I think in the record, my lord, your lordship will find the rules of executive business last time.
No, what is your, point of argument? You are saying that 11 March order,
Yes.
it was governor's order, and 11 March order, subsequent order is not governor's order.
No,
Then
it's
what-
not.
What is your point of
That's
argument?
that's my thing, and that's the answered by the
No,
learned single judge.
Yes, what is your point of argument?
Now, yes, that's why, my lord, I want to take your lordships to the rules of executive business. Thank you.
No, we do not see any difference in these two orders.
Yes, I'll take your
If
lordship to
there
that.
is some hidden difference, then please.
No, my lord, there's a very express differences there. I'm only on that point, and the learned single judge has said so. My learned friend did not reply to it. Your lordship is in 197.
Yes,
Now, your lordship kindly see corrigendum.
yes,
The administrative approval and expenditure sanction dated 1635, dated 18/3/2025, relating to the 6 numbers double lane bridges and ancillary works on Itanagar Jote Road, with an estimated cost of rupees so and so, with an expenditure restricted to rupees so and so, is cancelled due to the presence of some unintentional errors.
correct. This is in corrigendum only. Corrigendum need not be passed by governor.
No, but then this is a substantial amendment.
No, amendment is here. Amendment is the governor's order.
Yes, right. Now I'm taking to your lordship to that. Now this is your lordship, kindly see page 200.
Yes,
Number is 1965.
Yes.
Your lordship kindly mark it. Then your lordship kindly see clause 12.
yes.
Now here they have added the process of tendering and competitive
But
bidding.
this is passed by the governor only, right?
It's not by, that's my
This is
question.
The governor of Arunachal Pradesh.
It is written only.
Okay, and here also it is written only.
Yes, that's why, my lord, my endeavor was the last time.
Have you challenged this then?
Yes, we have challenged. We have, court asked them to present the record. They could not file that. And that is the answer given. That's why, my lord, your lordship kindly see what is the reply of the learned single judge. That is the only question we are required to, my lord, deal with. Para 26.
There are 26.
Yes.
Page? Yes, para 26.
Although the learned additional advocate general has sought to impress upon the court that cabinet approval was required to be taken for allotment of the said work, but the fact remains that the approval of the Honorable Chief Minister has been taken after the file was routed through the department. The administrative head of the department and the advisor West. Further, the order dated 11/3/2025, by which administrative approval and administrative sanction was given by the governor before the corrigendum or even after the corrigendum is with the concurrence of the finance department. Such being the position, the allotment of the works to the petitioner firm cannot be termed to be regular or illegal for that matter. On the contrary, in view of Rule 21(1), I'll take your lordship to
Which
this.
order allotment was given?
Beg your pardon?
By what order allotment was given to you?
Allotment of works.
Yes.
The walk,
That through extended contract, my lord,
Where is that extended? to?
that I'll take your lordship to the chief engineer's order at page 113. Not this, not this.
This is a work order.
No, 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 I'm taking care of it. That's 139. Your Lordship, kindly turn to page 139. This is dated 25/3/2025. That is after the corrigendum.
And 139.
In exercise, the Lordship got that.
Yes.
Page 139.
Yes.
In exercise of powers delegated under so and so, CPWD manual, technical sanction is hereby accorded to the works concession of 6 numbers double lane bridges for rupees so and so. Your Lordship, kindly see the date in the right hand side, 25/3/2025. This is even after the so-called corrigendum. Then your Lordship turn to page 144. Construction of 6 numbers double lane bridges and ancillary works of Itanagar Jyoti Road. Now,
What page 140?
141.
41, yes.
In the middle, your Lordship, kindly see history.
Mhm.
The administrative approval and expenditure sanction has been accorded by the government-wide number works PWD 1635. Your Lordship, kindly see 1635. That is the order at page 197.
Page?
Dated 197. Dated 18/3/2025 to amounting rupees so and so.
So these are all proposals and estimates, yes.
This is by the chief engineer on 25. Chief engineer is not going back to the corrigendum, because the corrigendum is no order at all. It's a inter-office communication.
And where is the order? Where is the order which has been given to you?
That you will perform that work.
No, that as your Lordship has seen from the office note, then after this page 114, I mean, the order dated 18/3. Through extended,
29/3/2025 order was issued to you.
then 18/3/25, this is the executive order passed by the governor.
So any order which has been issued to you is 29/3/2025
On the strength of
and,
the,
and 24/4/2025. These are
Yes.
2 letters.
yes, yes. On the
No other
strength,
letters is issued to you to perform the work.
perform the works, my lord, your Lordship has seen to, they have
These
asked
are
me,
all internal communications, some OMs, some proposals. That doesn't culminate to a work order.
my lord, your
Only
Lordship,
two letters were issued to you. Those are 28, which you have already challenged.
your Lordship, kindly see as page 122 to the General Manager Contract BMG, this is the respondent. Kindly dismantle the bridges carefully, avoiding any kind of accident.
Now, this is the go-ahead order.
Yes,
On the basis of this order only, you started working before financial sanction, before CM's sanction, before governor,
CM has sanctioned.
before governor's order.
After sanctioning, my lord, it has
No, no,
culminated.
this was on 2/11. And when is CM's?
CM, yes, CM, it is on 17/9.
17/9.
2024, no? 17/9/2024. Page 113.
Yes.
Then this office noting melody be culminated into an executive order. And the chief engineer, while giving technical sanction, he relied on this executive order number 1635. And now if they want to modify that, then the only question which is required to be answered is whether the government can modify without placing the same before the Council of Ministers, who is having the collective responsibility.
Whether earlier also it was placed.
Yes,
before.
it was.
Where?
My lord,
Where is
CM has approved.
CM is reported, there's a cabinet committee is required, CM. along with
Cabinet
two
committee,
ministers.
my lord, cabinet committee consists of chief minister, concerned minister, finance minister.
So three ministers.
They have
are required.
approved.
Now, where is that approval?
Well,
This
it is in the record. They are not denying
only
that.
CM, this is only CM has approved it.
CM and PWD minister.
CM is the PWD
Yes.
minister. But other two ministers, I mean,
Finance minister, he has approved.
there is a. quorum of
Financial
three
sanction
ministers, right?
is there.
So executive business,
Yes,
yes.
rules of executive business.
Now, if state of Arunachal Pradesh must be having one.
Lordship.
You must be having one. So how cabinet is formed and how cabinet approval is required to be taken?
Yes, these are clearly laid down, my lord. Your lordship can kindly
No,
see.
that is there, but from your documents, can you show that the cabinet approval was taken at that, I mean, when this was, you were saying that like CM has taken.
My lord,
signed it.
Decision of the appeals court, I will take your lordship to that. I will read the entirety of that.
CM is not only the cabinet, cabinet is a cabinet, cabinet consists of other ministers also.
My lord,
And there has to be some quorum for, I mean, in the executive business only, it is there most probably, we'll have to look into it. So there has to be, they say three ministers, right?
three ministers.
So three ministers, one person is CM.
One person CM,
He's the concerned minister.
he is the concerned minister Two.
Two persons he has covered.
and the finance
Yeah,
minister.
finance minister is there?
Yes, he has approved.
Where?
My lord, if they say, is the government record will speak.
No, where
If
is
the
that?
government hasn't denied that finance did not approve it, let him say very stoutly if he hasn't done.
One of the submission of the learned counsel for the appellant was that the learned single judge erred in not considering the fact as to why the tender process was not followed, which ought to have been followed, and why you have initiated the work without any work order. These two submissions were not contentions were not considered by learned single judge.
Now, this is not required in the sense, my lord, first thing, your lordship, if your lordship appreciate, this is a part of the extended contract only. So therefore, the moment chief minister has approved it and it has been culminated into an executive order, my lord, I have been asked to do the dismantling and all that. That is enough, my lord. The larger question is this, whether the government has the power to modify without following the rules of executive business in terms of specifically Rule 21(1). That is the larger question, my lord. Well, if I take your lordship to the rules of
I
executive
have
business.
not understood the meaning of the term extended tender and how it is different from extended contract. Whether extended tender, extended contract are convey same meaning or not.
Lord, in order to, my lord, DPR is very clear, that is said extended agreement of original agreement.
Yes, extended agreement.
Of original agreement. That means the very initial order, as I have shown you very initially, that is, my lord, initially it was 153 crores project. Both the items were included.
No, extended agreement is okay.
It is
That-
written in the, my lord, in the DPR, detailed project report.
So that agreement has to be changed or modified, or that has to be, addendum has to be added in the agreement, right? Whether that has been done. Nothing has been done.
There has to be some extended
Now,
additional agreement has to be there.
we are landing in such a thing, is such an, my lord, very urgent matter to construct the bridge. My lord, we are, my lord, in landing in the court now for emergency has gone into somewhere else.
No, that is the question before the court, whether there was an urgency. Otherwise, showing in the garb of urgency.
And clause 12 of the contract agreement, what is that? I mean, contract agreement is there?
12, my lord, as the clause 12.
Clause 12?
Clause 12, they are saying, my lord, initially what happened, it was done right from the many times, my lord, Under extended contract, they used to give the contractor who used to do the earlier works.
Correct, net for clause 12, I mean, is it on record, contract document?
No, that is, my lord, your lordship will find in the page 197, clause 12. And the contract also your lordship will find. Contract. General terms.
Yes,
My lord, your lordship kindly.
clause 12, clause 12 of the contract.
Yes.
Page,
Clause 18. I have a, my lord, loot sheet. I can take your lordship to that. I'm short of one more junior, my lord. I had all this duplicate.
No, I
copies.
mean, the contract agreement is not there.
Yes, yes.
You also don't have the contract
No, no,
agreement?
that I'm having.
Because I have annexed only those documents available in the writ petition. Your Lordship.
Your lordship kindly see clause 12 written. The engineer in charge shall have power to make alteration in omission from, addition to, or substitution for the original specifications, drawings, designs, and instructions that may appear to him to be necessary or advisable during the progress of the work, and two, to omit a part of the works for case of non-availability of a portion of the site or for any other reasons, and the contractor shall be bound to carry out the works in accordance with instructions given to him in writing, signed by the engineer in charge, and such alterations, omissions, additions, or substitution shall form part of the contract as if originally provided therein, and any altered, addition, or substituted work which the contractor may be directed to do in the manner specified above as part of the works shall be carried out by the contractor on the same condition in all respects, including price.
Well, Mr. Doctor,
Well-
this is for variation, right? So this is not a variation of contract, which we can see is very apart.
No, in addition, my lord, addition is also there.
This is not, I mean, variation is something where the scope of work is already given, some ancillary work cropped in. Then you do the variation work, the engineer will ask you to do the work, then you'll sign, both the parties will sit, then you'll see how much work has to be done, then prices will be decided, variation slip will be signed by both the parties, that will be kept on record. This is a variation, but this
No.
is not a variation. So
No, addition is also there.
so 12 is the clause 12. Actually, the approval was given for clause 12. Approval was not given for a extended contract.
12 is, it speaks about additions
Yeah,
and
additions
substitutions.
also, but additions can't be like more than the contract value. It's a like ancillary work. So the CM's approval, if at all was given, it was given for variation of work, not for an extended contract.
My lord, CM has very specifically said, Lord, I'll read once again to that, my lord.
No, I mean, clause 12, they have referred. This is very clearly, they have stated so. Subsequent upon receipt of sanction for additional cost of bridges, same can be taken up under existing contract as per clause 12 of contract agreement. So that cannot be done.
My lord, I'll read the once again, my lord, page 110. And then I'll take your lordship to the rules of executive business. Now, only question, my lord, if they want to say that we have modified. Now, so far the modification is concerned, let us see what rules of executive business speaks. कहाँ गया?
One thing, sir, so now, I mean, if the contract itself doesn't provide for certain things to be done, whether that can be just brought in there. Because clause 12 doesn't provide for that kind of work.
My lord,
So,
there are so many materials before the court, my lord.
so clause
Chief
12
engineer himself, my lord, even after the corrigendum, he is coming and
lot of
saying,
things have happened, that's a different thing, but whether the contract agreement itself permits for this kind of work, it
the
doesn't.
person has worked, he completed 2 bridges, other 4 bridges are also, my lord, he has undergone. Now, on the face of all these things, now if your lordship ask me that whether contract was allotted to him, my lord,
No, that's a primary question this court has to ask.
yes, definitely, my lord, and I'm required to answer to it. And because of this reason, my lord, the very constitutional question is before your lordships, and asking an answer from that. My lord, if, my lord, the earlier order was passed in compliance of the constitutional mandate and the rules of executive business, then any kind of modification, if the government want to do, they have the power to do. If they want to vary, my lord, yes, you have enormous power. But you are to do by in compliance of the constitutional mandate, whether you have done it. That's the question, my lord, and I just holding on that. The lordship now kindly take the Arunachal Pradesh rules of executive business. In exercise of the powers conferred by clauses 2 and 3 of the Article 166 of the Constitution, and in supersession of all other previous rules and orders issued on the subject, the Governor of Arunachal Pradesh is pleased to make the following rules, namely, these rules may be called the Arunachal Pradesh Rules of Executive Business 1987. This provision is very, very mandatory, my lord. And in order to buttress my argument, I will take your lordships to an judgment of the Honorable Appeals Court. Your lordship kindly see clause 6 onwards. Each department of the Secretariat shall consist of the Secretary to the government, who shall be the head of that department, and of such other government servant as the state government may determine. More than one department may be placed in charge of the same secretary. The work of a department may be divided between 2 or more secretaries. Now, this is in terms of 7 in terms of Article 163 and 166. The council shall be collectively responsible for all executive orders issued in the name of the governor in accordance with these rules, whether such orders are authorized by an individual minister on a matter pertaining to his portfolio as the result of discussion at a meeting of the council or of the cabinet or otherwise. Now, to 8. 8 is in terms of Article 154 and with Article 166. Subject to the orders of the Chief Minister under Rule 14, all cases referred to in the schedule your lordship will find in at page, your lordship is required to mark that also, at page 218.
We don't have the copy of that.
One copy, my lord, in the, I think it was in the reports, but one copy I'll furnish later. Subject to the orders of the Chief Minister under Rule 12, all cases referred to in the schedule to these rules shall be brought before the cabinet in accordance with the provisions of the rules contained in Part 2.
Clause 8.
8, my lord.
Subject to the orders.
No, schedule I'll come later, my lord. I am now on clause 8 at page
Yes.
202. Now, 9, my lord, that is in terms of Article 166(3). Without prejudice to the provisions of Rule 7, the minister in charge of a department shall be primarily responsible for the disposal of the business appertaining to that department. Then paragraph 10. No department shall without previous consultation with the finance department authorize any orders other than orders issued under an act or rules made thereunder or pursuant to any general or specific delegation made by the finance department. Now, your lordship may skip from that. Then your lordship kindly see.
So in your case, 10.1 is the one was not complied with.
Lord, In our case, your lordship will see at,
The 10.1 that you have read now,
yes,
it says that no department shall without previous consultation with the finance department authorize any orders
yes,
or so and so, orders issued under the act rule so and so, or pursuant to any general or specific direction, maybe the finance department which either immediately. So it cannot be ordered.
here in this case, my lord, the finance has concurred, the chief minister has concurred, the concerned minister has
It's
concurred.
there in the office notes. But but whether he was authorized, that executive engineer, that is the engineer.
And that office note has been culminated into main order, that is on 18.3. I have shown to your lordship that at page 197. And therefore, my
No,
submission would be,
just a minute. At page 197,
yes,
this clause 12 of the order dated 11th March,
right,
it speaks about approval of the government on 17/9/2024.
yes.
Which order it is referring to? We
I could not get your lordship.
come to page 197 at clause 12.
12, yes.
Last line, read last line of
Yes, the work shall be carried out through extended tender as per approval of the government by number 530 dated
the-
17/9/2024.
Which is this approval?
This is, my lord, your lordship has seen at the
CM's approval.
CM's approval, my lord. At page 113. In the left-hand side. UR number 530 dated 17/9/2024.
No, but the administrative approval and the financial sanction.
This is 197 itself, my lord. Administrative approval and expenditure sanction. And this clause 12, my lord, what I want to say, this clause 12 is said through extended tender. And the government is now saying they felt that there is some unintentional error. And your lordship has seen at page 199, they brought in corrigendum. The Supreme Court has said, my lord, corrigen, by bringing in corrigendum, you can make a clerical correction you can make. But a substantial departure from the original agreement, you want to change to some other, you can't do that. And even in the rules of executive business speaks, my lord, if you want to do it, you will have to do in the similar fashion. You'll have to place before the cabinet, then chief minister will approve.
No, where is the note for administrative approval?
My lord, when the chief minister approves, he approves at its entirety. Then after that approval, my lord, it will go to the governor. Governor will make a notification. The notification will be expressed in the name of the governor.
Mr. Datta,
No.
we are, I'm sorry to interrupt. I mean, one thing only we just wanted to understand. See, where in the CM's approval, I mean, it has been, I mean, the approval has been given for extending order, extending.
Does the wordings are there, my lord?
Where?
My lord, I'll read once again, my lord.
When it
It
comes
is,
to clause 9, ultimately they come to the conclusion 9, right? Serial number 9,
No.
page 111.
is page which one? 115.
So if you read
The one, my lord, 7, your lordship, 115, your lordship, C, the methodology and terms of procurement can be considered as additional work by extending the,
115 is not, we are not talking about 115, we are talking about 503, right? Note number
503, right, yes. 503,
503, page 111,
yes, is
the
11,
type portion.
yes,
Type portion is at 111, correct? So now it says that under prevailing circumstances, it is recommended to adhere to the following norms compatible with CPW Works Manual 2022.
yes,
Assigning contractor so and so to carry out subsoil investigation, design, preparation of structural drawing through consultant, followed up with proof check and vetting of so-and-so, BBQ for bridges so-and-so. RCC structures will likely to take 2 years time and not feasible in the context of current situation, entailing all weather road within CFY expenditure so-and-so. Then design can be met out and the provisions already covered in the proposal subject to sanction of by the government. It is again sanctioned by the government. The power of engaging private consultant is vested with SCCE as per serial number 36, annexer 66A. So it is only with SC and CE of SOP to CPW work so-and-so. Subsequent upon receipt of the sanction of additional cost of bridges, same can be taken up under existing contract as per clause 12 of the contract agreement.
Yes.
So it doesn't say that it's on the existing contract or extended contract. It doesn't say so.
Your lordship
So
will find the,
clause 12 is a different thing altogether. Clause 12 is a variation. The variation has to be done here as per the contract. In your contract, nothing has been done as per the variation.
your lordship may see the chief minister's approval,
No,
at page
correct.
115.
So now how can you argue that this 197,
Yes.
that 197 is has the CM's approval? The work shall be carried out through extended tender as per approval of the government. I mean, it was not approved that way.
No, no,
It's
as per
a complete-
approval of the government, white number 530.
Correct. So this is misrepresented.
Lord, this is then the governor will have to explain it.
Correct. So I mean, now clause 12 is totally different. So now because of this mistake, they have corrected it.
No, no, how can we, this is a mistake. my
No,
lord.
no,
This is
wha-
they are referring to the
One
well,
more-
chief minister's approval order.
One more aspect is there. This order at page 197, order dated 11/3/2025,
Yes,
was passed on the basis of administrative approval and financial sanction granted to a particular project on the basis of certain notes.
yes.
That administrative approval was concern note sheet is at page 48,
Yes.
which
My lord-
does not speaks about this last.
My lord, should your lordship look at page 48, which is not the recorded
No.
thing in the read court? My lord, initially
Page
I
48.
told that these are the papers inducted here only in the writ appellate court.
Page 48.
Yes. The very initially I told all these things. Annexure 2 and 3. Is total embarrassment for us, my lord. And that's the reason, my lord, initially before he starts, I said all these things. Because something unheard of that some papers comes which were not part of the record. The learned Singh just could not deal with all these things, and even we also. And these are all, my lord, the letter of modification. And modification will have to be done in compliance with the constitutional mandate.
But this is an office memorandum. I mean that page 47.
No, no, I'm not on that, my lord.
But
Whatever it may be, are these
I'm-
the
I'm
part of
not
the record?
I'm not on 47. 48. The note on the basis of which this
No, I understand, my lord, what your lordship is saying. Your lordship is very correct, but are these the part of the record of the read code?
suppose this order contains something which was not approved, how the court will know unless we go through the.
No, the question is then, my lord, your lordship, we are to going back to a certain thing that which are not part of the record, and we are to appreciate all these things. Is a reopening of the writ petition itself. And so far my knowledge goes, my lord,
This note sheet was not produced by.
no, 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 never. We requested the court to call for the records.
Because
They just-
this order 11/3/2025 appears to contain something which was not approved
I have seen that, my lord.
while administering. And
Those are the juggleries, my lord, I am saying very clearly. My lord, jugglery in the sense, you want to modify it. Can the chief engineer can modify? Can the executive engineer can modify? These are all constitutional area. You'll have to go to the, my lord, the governor to see all that thing. It'll have to be placed in before the council of ministers. They will all at their wisdom, they will see to it. And the chief minister will approve it. He may not approve also. If it approves, it will go back to the governor. and the notification will pass in the express in the name of the governor only. Now, those are the, my lord, constitutional mandate, one has to go through it. Otherwise, chief engineer can, at his whims, can do many other things. He has said, one day what he is saying, one bridge you stop. Other day he has come, he has said, two bridge you stop. Then he said, only in case of 4, you can issue tender.
No, without looking into those documents also, 197, your basic argument is 197,
197.
which has sanction of the governor.
Yes.
Has been done following the due process of law, executive business, correct? But now, in that order itself, this note, the work shall be carried out through extended tender as per approval. That is not correct. That is not there.
The approval is for that only.
No, for extended tender as approval. Approval was done in a different manner. Approval was done saying that as per clause 12. The clause 12 is different of the contract agreement. It has been specifically approved on the basis of clause 12, but clause 12 is a totally different thing. Clause 12 doesn't
Clause
allow
12 of the contract.
Correct.
Contract clause 12 also speaks about additional works.
Orders additional works which are ancillary. Additional work doesn't mean you give a, I mean, when your base contract is 60 crores and you give a 80 crores of additional contract.
Base crores is my lord 153. Original project cost
No,
153
that is
crores.
different thing. But like contract you were executing, the contract agreement on hand, that is of 60 plus some crores. Now
They
you are
have-
saying that I'll do some additional work which is worth 80 crores.
No, it's not like
The
this.
clause-
They have bifurcated.
No, clause-
Originally
That's why
153
I'm saying
crores.
clause 12 is a variation clause. Clause 12 is only within the scope of the contract only you can do, which is out of the contract you cannot do.
My lord, up to your lordship, my lord, I will not go to
That
that.
cannot be done.
My
So-
submission will be the approval was in regard to the extended tender, and it's very clear there is no via media, my lord. And my submission would be the modification, anything done, it will have to be in terms of the rules of business 21(1). And my learned friend could not reply to this. Your lordship kindly see to that. Rules of executive business.
Let's see their reply to this. Which para?
Uh,
Their affidavit?
21(1).
And their affidavit, you have replied to this. This is whose document is this?
Which one? my lord?
197 who has brought in?
This is a government document.
You have brought-
Yes, that's my document.
197 is yours.
Yeah, my document.
What have you stated there in your affidavit? Which para?
Para 3 lawsuit.
Para?
Para 3 of my affidavit.
Okay, let's see.
Page
Affidavit starts from lawsuit page
183.
183. 181 lawsuit.
Yeah.
And relevant is 183. I'm sorry, lawsuit. Paragraph 13. So per that particular section
Yes,
order is
para
para 13,
13.
Which one, please?
page 189.
page 189.
89 lawsuit. Para 13 lawsuit. Down below, bottom.
No, it admittedly, my lord, they corrected through corrigendum. Earlier it was through extended contract. Lord, I will only say in a democratic setup of the state government must reflect the collective wisdom of the chief minister. Now, the very conduct of the government, your lordship, has seen para 13. They're admitting that they have the modification on all these things. The correction have been done through corrigendum. My lord, is it sufficient? Now, in that context, my lord, I'm inviting your lordships to Rule 21, one of the, my lord, rules of executive business.
No, after the corrigendum, this order has been passed. No?
No, that cannot be.
After the corrigendum, the order has been passed. It specifically says governor has approved this. The governor of Arunachal Pradesh is pleased to accord administrative approval and expenditure sanction.
My lord, I fail to understand if any constitutional correction has to be done. Can it be through corrigendum?
Is it no, not for the from the corrigendum. This has been on the approval of the government.
That is the reason, my lord, I requested the honorable single judge to call for the record to show that where the governor has acted on it. They could not bring the, well, they could not show from any record, some photostat copy only. And that's the reason finding is very clear. So therefore, unless, my lord, democratic setup has been twisted in that manner.
But
when
now,
they-
now you are saying that like earlier order was by proper
Yes,
manner.
yes.
But
That-
this has been wrongly included, extended contract. It was
No.
not there in the extended contract.
My lord, I don't know, my lord, the government has even in their affidavit, they have said.
All those things are before the court only. Nowhere we can see that extended contract term is used. Only in this order we can.
But
see that-
if I read
and
the,
refer to a clause 12. Clause 12 doesn't talk about extended contract at all. Clause 12 talks about something else, variation.
clause 12 of the contract,
Yes.
my lord, I'm sure that addition word is there.
Addition
If
is
addition
different.
order is there,
Addition
it
doesn't mean,
includes-
addition doesn't mean you add a different.
That's my interpretation, my lord. It's up to your lordships to see in whatever way it is. But my interpretation, addition includes the extended tender. ठीक है subsequently they have come out. Uday. Uday. Lord, I'll invite your lordship attention at page 147. What government is saying, whether it is an extended agreement or not.
140.
147. And the top
Yes,
your
what
lordship
is
will
this?
find extended agreement of original agreement. Then, my lord, in the page 148, in para 1. This is made as extended part of original agreement dated so and so.
Now, this was done when?
This 11/4. 11/4/2025.
But this is the extended agreement you entered with
Yes,
government.
yes, yes.
This is the document we have been asking you from the very beginning.
Yes.
Oh, I missed it. My learned friend insisting
We have
me.
been asking that like where is
Where is that
work order?
No, no,
whether
I
there is
understand,
an
my lord.
extended agreement.
Even he was
Even
also
after
insisting me.
2.5 hours, he was saying this is the document.
Rightly, my lord.
From the very
Even,
beginning, we have asked for this.
even he was poking me, but then I just missed it.
This is for 2 bridges.
ठीक है भाई, 2 ब्रिज तो किया आपने, उसमें क्यों नहीं
For
बोलते?
2 bridges.
For 2 bridges.
They have cancelled the work order or what regarding other 4 bridges only.
In fact, no formal order was issued.
No,
And-
what were the impugned orders
Impugned
before
order, we have decided to go for tenders in respect of 4 tenders,
in respect of 4 bridges only?
which has been question set aside by the land.
No,
So these 2 bridges.
and
we-
these 2 bridges are not included in that impugned order.
Not included. In rather lordship, in impugned letter communications, we have stated laws so far 2 bridges are concerned, these 2 bridges. We regularize it in favor of the writ petitioner
So that's why you have done this agreement you have entered into.
lordship.
So these 2 works, there is no problem
There is no dispute also.
because they have done it and you wanted to regularize
The
also.
question would be, my lord, if it is extended contract is applicable in 2, where is the bias in regard to the 4?
Yes, that we are asking. Where is the extended contract in respect of remaining?
Extended contract, my lord, in respect of 6 bridges, all along, my lord, in all the papers, your lordship has seen that. Now, only
No,
thing
just
subsequently,
like you have shown us extended agreement in respect of 2 bridges.
now they have come up for 2, but then if it is applicable for 2, why not for the 4?
No, that
And-
we are asking. Where are those?
That's why, my lord, your lordship kindly decide. Now, in regard to, I am on regard to modification of that from the extended.
And one
contract-
query to you, Mr. Datto.
Beg your pardon.
In like
Right.
the 11/3/2025 order, sanction order, there please that it is not in terms with the administrative sanction and financial sanction that was accorded. Because in the office note, no such thing like extended tender was there.
My lord,
Your please that that document was not before single bench.
they are the authority. Let them show the record, my lord. And the original record, not photostat, my lord.
Originally.
The last time also they produced photostat.
The documents, the note sheet which we have annexed in the writ petition,
No, why don't you bring the record?
Original record,
Original record.
note sheets.
note sheet, because it's e-file lordship. And it has to be downloaded from the
No,
lordship.
you'll have to do it. You'll have to do it.
Oh, this is the downloaded copy.
Yes, it was downloaded and it was placed before this honor court laws. Even it's reflected in the paragraph 15 of the judgment, impugned judgment laws.
No,
Let
no,
us be fair to the court.
He's talking about,
My lord, 65B will come.
other than these 2 documents, is there any note sheets? Is there any approval? Proper approval was done before the corrigendum was issued. That is his argument. That we have not brought anything on record.
Details of the notes is given here also. From page 48 to 65 also. Page 48 to
No,
65.
those are regarding the first, this thing,
No, second.
48.
This present current the work only those.
Okay, this one, this
cabinet-
this is the record that you have
This is the
got.
record.
You're talking about these ones,
This.
okay.
Internal also the process has been.
My lord, so far the electronic record is concerned, photostat will not do before the court because it will hit by 65B. They'll-
65B has been diluted in many things.
No, I can take your
In
lordship to
many
that
things,
decision.
It has been diluted.
My lord, I'll,
You get a certificate, you get a certificate,
yes, you'll get the
get a
certificate.
certificate. Let
They-
me produce the
They
record,
can do
get a
that.
certificate.
I'm sure they will fail to show that modification in terms of constitutional mandate and business exhibit. Otherwise, they could have done it in the last time also. They haven't done it because the way they filed the affidavit, it proves that. Otherwise, there should not be any hide and seek business.
Yes, Mr. Datta, how much you conclude your argument?
No, I haven't concluded, my lord. I have so many decisions of the appeals court. My lord, if they want to file the record, the lordship give them short time,
No.
then I will advance my argument. Because my question,
When will you be able to produce?
I think just I instructed my
Like tomorrow or day
Tomorrow,
after tomorrow. we're fixing it.
we'll continue tomorrow. Yeah, along with 65B certificate.
lordship. That's certification would be their lordship.
Certificate, I mean, see, 65B to only from your computer operator, you'll have to take it.
Yes, lordship.
That it isn't properly downloaded, the same thing. That's, you'll have to take it from your government official only. I don't think that will take some time.
Lordship.
But you may continue.
I'll continue. Even my lord, if your lordship, they have annexed certain papers which were not papers in the read code. Even from there, your lordship will find nowhere that the concurrence of the governor was there. They haven't said that. And they haven't done it, my lord. For
corrigendum.
only on the basis of corrigendum, they have come. Well, the corrigendum, strength of corrigendum is what? Supposing there is a clerical mistake from 151, it should have been 152.
So for clerical mistake also, they have to go back to.
No. For that it is not required. But here what is happening? Substantial amendment you are making. Now for that you will have to place your lordship 21. One is very clear of the rules of executive business. Well, these are, my lord, the certain things framed by the, my lord, the state is not without any meaning. It has to be done in that particular manner. Otherwise, my lord, there will be chaos in the state. Whatever chief engineer thinks, my lord, tomorrow I want to do this, he can do it. Because of that, my lord, these are all
No,
governmental.
that is not their stand is different. Their stand is that the administrative approval and financial approval was when it was granted, there was no stipulation there regarding this extended contract. It is only there in the order dated 11/3.
No.
Therefore, they have rectified.
No, my lord, my argument is this. Which one is the executive order here? The order dated 18/3. 11/3, but then signed on 18/3. Now, if your lordship look at that, this is an executive order in toto. Now, subsequently, they come up with a plea that no, with the corrigendum, it has been modified. Now, can you do that? 21, my lord, I'll just read for my satisfaction. Just 1 minute, my lord. When a case has been decided by the cabinet after discussion at a meeting, the minister concerned shall take action to give effect to the decision. If, however, your lordship kindly see, if, however, any deviation is proposed to be made from that decision, the case shall be submitted to the chief minister by the minister concerned, and the chief minister shall direct that the case be brought before the cabinet or for reconsideration, save in an emergent meeting, where further action on it will be taken according to such direction as the Chief Minister may deem fit to make. The Secretary or the department concerned will in each such case cause to be supplied to the Secretary to the Cabinet such documents, whether these are compliant. Now, these are all mandatory provisions. Supreme Court has said, once you do not cover these, well, it is a nullity, it is a void ab initio. Now, on the face of it, my lord, can you do all these things, all this modification by, my lord, making an corrigendum?
No, but cabinet decision, where is the cabinet decision approval?
That is what I am asking for.
In the initial order also, there is nothing, no cabinet order.
My lord, the
Only chief minister's approval.
Chief Minister approval, my lord, it will stand before
Is there any document showing it was placed before a cabinet?
my lord,
show
is
me
the
that.
government has to
No,
reply.
you are arguing that, no? Because you are.
I am
saying that-
arguing,
no, you are saying that it has been placed before the cabinet. Cabinet has approved it.
No,
Now
then
you
let-
now
my
you cannot
friend is
modify it.
there.
Now you cannot modify it. Now you show me that like cabinet has taken a decision. Where is that?
That is, how can I say, my lord, he has to
It
say,
is your argument.
my argument will
Your
have to
argument
be.
is your argument is that cabinet has approved it.
Lord,
Now where is the cabinet's
if your
approval?
lordship ask me the negative question without asking
Not
him,
making- see,
he is the person, he is the
Mr.
architect of all
Doctor,
that.
You have argued that cabinet has once approved it.
Now,
Okay.
why your
No, no,
lordship disbelieving me?
Once it has approved it, it has gone to the governor. Now governor has issued that order. Now you cannot modify it without placing before the
No, no,
cabinet.
no, what I am
That
saying,
is your argument.
in 18th March's order, I am saying it's had been ratified by the chief minister, it has gone to the governor. Governor
By
has
the
passed
chief
an order.
minister, not by the cabinet.
My lord, then they has to answer it whether it is like
So
this.
executive business says cabinet.
Cabinet, I am also,
It doesn't say,
cabinet,
it doesn't say chief
your lordship,
minister.
your lordship kindly see, just for once, I'll read just one line. Cabinet or chief minister,
Okay.
cabinet or chief minister,
read-
just whatever.
Please read it. But as per the document they have given. it's
I'm not
cabinet.
saying just like that, my lord. I have the authority. with me.
Please read it.
After the concurrence of the finance department,
From where you're reading? Which document is this?
2010-11 SCC 374.
A case law you're reading?
No,
No, you were
position.
you were reading the executive business. You read that
I'm-
provision.
Yes, I'm saying that what is the provision of law, it may be sent to the cabinet or the chief minister.
No,
It's not,
that the interpretation of law will say, but what is the executive business? say?
yes. 21-1.
Yes. What does it say?
They're very clear, my lord. There is no ambiguity. Where a case has been decided by the cabinet
Yes, cabinet.
after, oh God.
Yes, cabinet discussion. Yes.
When a case has been decided by the cabinet after discussion at a meeting,
Mhm.
the minister concerned shall take action to give effect to the decision.
Mhm.
If, however, any deviation is proposed to be made from that decision, the case shall be submitted to the chief minister by the minister concerned, and the chief minister shall direct that the case be brought before the cabinet or for reconsideration, save in an emergent situation where further action on it will be taken according to such direction as the chief minister may deem fit to make. The secretary of the department concerned will in each such case cause to be supplied to the secretary to the cabinet such document as the latter may require to enable him to maintain the record of the case. Now, your lordship, if it is
So,
not
and
done in
cabinet
that,
has been defined, right?
beg your pardon?
Cabinet has been defined.
Yes, yes.
So cabinet means committee of council, committee of the council,
Council of Ministers.
council of ministers. So here was there any cabinet decision in your case?
Lord, I am saying so many a times that this is the governor's order. And if my London friend said it's not, has he said it's not? If he says it's not, my lord, let him produce the record. You have come here for a valid adjudication. If your lordship thinks that I'm not correct, let him say by producing the record. That is what I am saying, my lord. We are here to get
Okay,
an,
we'll continue then.
We'll continue tomorrow.
Tomorrow we'll continue.
my lord, record will be necessary in that case, and the entire record
No,
should be
they
placed.
will bring record.
And so far 65B will be, compliance will be required. Otherwise, my lord, the government should not take us on a back foot.
Will you be able to
I'll try my best because it's already one. I'll
tomorrow or day after?
Let him be
Day after
sure
tomorrow.
because
day after tomorrow though, I think I can ensure, but tomorrow I'll try my best.
Or-
Because Mr. Doctor has come from Guwahati. Huh?
Oh, yes.
So I mean, if you can do it tomorrow, it will be better because he's. I
Yes,
mean,
that's I
so
just.
tomorrow not a problem, no, Mr. Datta?
Tomorrow, holiday. After is a
Or
holiday.
day after tomorrow is a holiday. Yes, yes, yes. Tomorrow you'll have to bring it.
Tomorrow,
Or on Thursday. Tomorrow is good. We'll hear.
Tomorrow, I doubt, my lord. I can tell your lordship that those, what is called? क्या बोलते हैं? Certificate.
Certificate is not a very.
No, for them, it's a very high thing. I know it. The last occasion also, they did not do that. Because I was insisting them, please do it. They did not. And in a course of a day, I don't think they can do it.
so for productions of the document is concerned because before Lana single bench, I didn't appear. My colleague appeared in the case.
Okay. Okay.
So-
What is your name?
My Subhu Tapin.
Heard Mr. Subodh Tapi, learned counsel for the appellants. Also heard Mr. S. Datta, learned senior counsel, assisted by Mr. S. Datta, appearing for the. How many respondents are there? Only you.
All the respondents.
eh,
Sorry, I'm for the feeling. Only one sole respondent.
So, appearing for the sole respondent.
You're so swayed by the case.
Though the matter was heard substantially, the hearing could not be concluded. Therefore, list this matter tomorrow as part heard matter. Stop. In the midst of hearing, it was contended by learned your senior government,
Senior government.
learned senior government advocate that the order dated, that the administrative order according administrative approval and expedition sanction dated 18/3/2025 was based on the note sheet to that effect dated 7/2/2025, wherein no such stipulation that the work shall be carried out through extended tender as approved by the government wide number 530 dated 7/17/19/2024 was there. He submitted. Stop. On the other hand, learned senior government and learned senior counsel for the respondent submits that the said note sheet was never produced before the learned single bench before the writ proceeding. Be that as it may, we are inclined to go through the said note sheet. Hence, the government, learned senior government counsel is directed to produce the said note sheet before this court. It was also submitted that this said note sheet is maintained in e-form in the computers and therefore only a downloaded version of the said note sheet may be produced. The prayer is allowed. However, it is made clear that if downloaded version of the said note sheet is produced before this court, it shall be supported by necessary certification under section 65B of the Evidence Act. List this matter again tomorrow.
Tomorrow, I'll step it.
As part of matter.
Obliged.